A very good evening to all of you. So today we have all gathered to discuss a topic which is of extreme significance. It has always been very, very important, but it is in contemporary times that it has assumed even greater significance. And that is because a constitutional goal that was enshrined in our constitution at the time when the constitution was enacted, and it has taken so many years for one state to finally come up with a law in this regard. So, what is the Uniform Civil Code that everybody seems to be talking about nowadays, especially after Uttarakhand has enacted a UCC? So, let us try and understand what is UCC and what is so special about the Uttarakhand Uniform Civil Code. So, I've prepared a PPT that I'll be sharing with you. So first of all, what is Uniform Civil Code? So the literal translation would be Samaan Nagrik Samhita. Now, see, is this actually, so relevant that we are talking so much about it, and why should there be an opposition to this in the first place? Because at the end of the day, we are all citizens of India. We should all be governed by one set of laws. And we are being governed by one set of laws when it comes to all our criminal laws, when it comes to law of contract, when it comes to law of torts, when it comes to environmental laws, consumer protection laws, when it comes to the procedure relating to civil laws also, we have one uniform law. So why so much of a controversy surrounding a civil code? So what is the civil code? So let me just tell you that Uniform Civil Code, what it is a proposal in India that is aimed at replacing personal laws that are based on religions, customs, and traditions with one common law for everyone, irrespective of religion, caste, creed, sexual orientation, and gender. See, as it is in our country, we are all governed by uniform laws in most of the spheres. But when it comes to areas such as marriage, divorce, inheritance, succession, adoption, maintenance, so now these are areas which people are governed as per their religious laws. So they are known as personal laws. So for a Hindu, the marriage, they will be governed by the Hindu Marriage Act. And a Muslim would be governed by their own personal law. Similarly, Parsis, Jews, they would all be governed by their own set of personal laws. Therefore, we have multiple laws which govern us people who are governed by one criminal law. But when it comes to our personal matters, we are governed by different religious laws. And why is this happening? Because we celebrate our cultural diversity. So at the time when we were granted independence, at that time also there was a proposal to implement the UCC. But what happened, because the majority of population consisted of Hindus, so there was this kind of a concern that the minority communities should not feel that the majority community have imposed their own religious practices on them. Because when we talk about personal matters such as marriage, divorce, succession, so there are so many other cultural traditions that are attached to these aspects of life. So that is why UCC, instead of being converted into a concrete law, it was put in the constitution in the form of a constitutional goal that in future, when the time is right, we will implement one set of uniform laws that would be governing all of us, instead of having multiple laws which are rather divisive. What we would try to do at a future appropriate time, we would try to bring in a law, a uniform law, which would govern all of us in the same way as we are governed in rest of the matters. So Article 44 of the Constitution, it says, the state shall endeavor to secure for the citizens a uniform civil code throughout the territory of India. Now, there is Article 37 also in the Constitution, which says, directive principles are guiding principles for government policies. They are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. However, Article 37 of the Constitution itself makes it clear that the directive principles of state policy shall not be enforceable by any court. But there is a duty on the state to enact laws to implement those directive principles. And that is the reason why the law relating to environment has developed, why we have enacted so many laws to protect our women, because that is what our directive principles say. That see, we are supposed to protect all our people. So now the directive principles that have laid down certain goals which support our fundamental rights also. And in order to give effect to those directive principles, we are supposed to make laws as and when the time is opportune. And that is what Uttarakhand has done by enacting a uniform civil code for their state. Now, Article 25 to 28 of the Indian Constitution guarantees religious freedom to Indian citizens and allows religious groups to manage their own affairs. That is fine. We all have the right to practice. We have the right to propagate our religion. We have the right to celebrate our festivals. We have the right to follow our own customs, traditions. But when we talk about uniform civil code throughout the course of the seminar, we will try and understand why people misunderstand UCC and why they don't understand that UCC is not going to pose any threat to our cultural diversity or our religious freedoms. What UCC is trying to do is usher in a uniform civil code which will regulate us in our we don't call those personal matters anymore. They would be matters like marriage, divorce, succession. Why? Because we live in a rights-based society. So rights, they should be same for all of us. We should all be governed by a uniform set of laws, and religion of all the things should not be allowed to be used as a tool for oppression of some people or oppression of certain group of people, whether it is women, whether it is children, whether it is men. So UCC, it will cover marriage, divorce, inheritance, succession, adoption, and maintenance. Although when we go through the provisions of the Uttarakhand Uniform Civil Code, you will realize that adoption and guardianship, they have been left aside. And the reason is we already have provisions for adoption. We already have CARA guidelines, and we already have provisions under the Juvenile Justice Act, which is a secular law. So when we already have a secular law governing us in those matters, then we have the Guardians and Ward Act, which is dealing with concept of guardianship. So as it is, we do not need any more separate laws in this regard. So what is the genesis of the concept of Uniform Civil Code? See, Romans, they have ius civili. So Romans, that was way back, that their Roman emperor of the Byzantine Empire, Justinian, he had codified the entire bulk of civil, criminal, everything, all the laws, they were put together, and they were known as the 12 Tables of Rome. So Romans, they have this law, which is a legal contemporary term that upholds all the rules and principles of law which have been derived from the laws and customs of Rome. And all Romans, they are governed by that single set of laws. So Uniform Civil Code is followed in countries such as UK, France, even in America. See, California has a family code that applies to all citizens regardless of their religion. Then our neighbors such as Pakistan, Bangladesh, other countries such as Malaysia, Turkey, Indonesia, Egypt, Ireland, you see all these countries, they have one set of personal laws for all religions. See, there is always one religion which is in majority, and there are some other religions which are in minority. But what they have done, they have made one set of personal laws that is applicable to all people of all religions, and there are no separate laws for any particular religion or any particular community. In India, in 1840, there was this Lex Loci report in October 1840, which emphasized the importance and necessity of uniformity in codification of Indian law relating to crimes, law relating to evidence, law relating to contract. But that report, it recommended that personal laws of Hindus and Muslims should be kept outside such codification. Now it is anybody's guess why they did not want to codify our personal laws. And the plain reason is the divide and rule policy of the British Empire. They did not want Hindus, Muslims, Christians, everyone to be united here. That is why the most divisive thing that can divide people in religious matters is when you govern their personal matters as per their different religions. So that was the reason why they were opposed to a uniform civil code. And what they did for Hindus, when they talked about codification of our personal laws also, it was like the diverse, the Brahminical customs, they were accepted. And the reason was because in Hindu religion, there is this Varna system. So the Brahmins, they were in a dominating position. So what they did over the rest of the Hindus also, most of the Brahminical customs were imposed, and that was presumed to be the Hindu law. Although that is not uniform, that are not the practices which are followed by all the sects and all the groups amongst Hindus also. So that is what they did for Hindus also. Amongst Hindus also, they tried to create a division. And for Muslims, what they did, diverse local customs were there. So they enacted a uniform Sharia law of 1937 to govern all Muslims. However, local customs were allowed to outweigh the written text of law. So after independence, now Hindus, they have to follow the Hindu Code Bill of 1956, which was split in the form of 4 separate enactments: the Hindu Marriage Act, the Hindu Succession Act, the Hindu Minority and Guardianship Act, and the Hindu Adoptions and Maintenance Act. Muslims and other religions, they were at the liberty to follow their own respective laws. For Muslims, the Sharia prevailed, and all the time, whenever there is controversy, the All India Muslim Personal Law Board, it keeps on attempting to try and decipher what is the correct interpretation of Sharia and all. See, at the time when the Britishers suggested codification of our criminal laws, at the same time they enacted a secular special marriage act also. That was in 1872, but this law had a limited application because it required those who sought to be governed by this law, they were supposed to renounce their religion. In 1923, the Special Marriage Amendment Act, the law was amended partially. And what it did, it permitted Hindus, Buddhists, Sikhs, and Jains to marry either under their personal laws or under this Special Marriage Act, and they were not supposed to renounce their religion, and they could also retain their succession rights under their own personal religion. Then, in 1954, we got this present form of Special Marriage Act, which provides a form of civil marriage to any citizen, irrespective of religion. Thus, Indians, they are permitted to marry outside the realm of any of their specific religious personal laws. So under this law, polygamy is illegal. So irrespective of the religion to which you belong, polygamy is not permitted if you are married under the special marriage law. And inheritance and succession, they would be governed by the Indian Succession Act rather than the respective personal law. Divorce would also be governed by the secular law, and maintenance of a divorced wife would be along the lines that are set down in the civil law. Therefore, the Special Marriage Act, it provided significant protection to religious minorities, which could not be found in the personal laws of their religion. Indian Succession Act 1925, it governs the wills that are made by Hindus, Sikhs, Christians, Jains, Buddhists. However, Muslims, they are not governed by this law. Now, does it mean that throughout the territory of India, we did not have any civil law? We had one civil law, and that was the Goa Civil Code, which is also known as the Goa Family Law. See, Goa Civil Code is largely based on the Portuguese Civil Code of 1867, which was introduced in Goa in 1870. And then it was introduced in Goa, and thereafter it was extended to the provinces of Portugal also. So, after the merger of Goa with India in 1961, although in rest of the matters, Goa was governed by the Indian laws, but when it came to civil matters, the civil code, it was retained in Goa. Okay. So although Portugal, they replaced their law, but in India, in Goa, we continued with that civil law. So there is one single code which governs all the native Goans and the native Damanis of Daman, Diu, and Silvassa, irrespective of their affiliation to religion, ethnicity, or social strata. Now, what are the features of this Goanese civil code? There is the concept of common matrimonial property, which is such a good concept, and somehow in the Uttarakhand civil code also our lawmakers have overlooked this provision. See, in our society, which is largely patriarchal, we don't put much of an emphasis on educating our girls, due to which what happens most of the time, women, they take care of the household and men, they work outside. So what happens, the energy, the time that women put into domestic work, that doesn't translate into monetary terms. So all the money that is earned by the man, and it is seldom recognized that a woman, even if she is not earning, she is saving by contributing towards the family. But what happens that the earning capacity, because it rests in the man, the properties and all are usually held in the man's name. So God forbid, if tomorrow there is a fallout between the parties, the women, they are left with nothing because there are no properties in her name. So in Goa, there is the concept of common matrimonial property, that whatever the couple generates during the course of their marriage, at the time of their split, it is divided equally between both the parties of the marriage, irrespective of who earned what. Both of them, they are considered as equal contributors to the property whatsoever they have managed to accumulate during the marriage, and that is split equally. So that is a very good concept in the Goa Civil Code. There is also a provision for prenuptial agreements. Hindus regard marriage as a sacrament. In Islam, it is regarded as a contract, but all said and done, somehow we frown at the concept of prenup. We feel that maybe too much of materialism is creeping in when we are talking about prenups at the time of marriage, or even before marriage, if we are thinking about separation. So all these kinds of beliefs, they cloud our understanding. And somehow we have not accepted that, see, this is the time when we need to introduce the concept of prenuptial agreements, so that both the parties are very clear about what are their expectations from their relationship, and then the eventuality of a divorce or a separation, what is it that either one of them would be taking away from the marriage. So in Goa, there is a provision for prenuptial agreements, prenuptial public deed regarding the disposable of immovable and movable property in the event of divorce or death. See, nowadays our courts, although we don't have a concept for prenuptial agreements, but in case there is some sort of an agreement between the parties, that definitely provides an easy exit point to the parties in the event of a divorce, and it facilitates an easy and a lesser messy settlement. Then another feature of this Goa Civil Code is parents, they cannot divest their children of property completely. At least 50% it goes to children irrespective of their gender. Another thing, Muslim men whose marriages are registered in Goa, they cannot practice polygamy. And surprise, Hindu men have right to bigamy. See, no other community has been permitted. So for Hindus, if a wife fails to bear child before 25 years of age, or if she fails to bear, more specifically, a male child before she attains 30 years of age, then in such cases, the man has a right to remarry, and he has a right to have a bigamous marriage. Now, what kind of a law is that? See, after independence, Hindus, they introduced the concept of divorce. Divorce is something which is alien to Hindu religion, but it was accepted in Hindu marriage laws, and slowly, people also accepted it. So sometimes what happens, laws, they have to take some sort of a strict law, it has to be enforced, because laws, they are a potent tool for social transformation. So, in order to protect the rights and interests of parties in a relationship, sometimes we need to make certain laws which might be against the religious beliefs also, which might be against the customs also, because at the end of the day, we live in a rights-based society and we are to be governed by our constitution in all respects. Thereafter, in Goa, verbal talaq, it is not accepted. Roman Catholics can solemnize their marriages in church after obtaining an NOC from the civil registrar. For others, only a civil registration of marriage is accepted as a proof of marriage. Then there were divorce provisions under the civil law are not applicable to Catholics marrying in the church. So as it is, you see, although Goa has a civil code which is properly codified, but it is not uniform for people of different religious identities who reside in Goa. Further, what it says is that every birth, marriage, and death have to be compulsorily registered. And this is a very good provision because it effectively checks child and bigamous marriages. Now, why do we need a uniform civil code? Because as I just said, we live in a rights-based society and every individual's rights, they are to be protected at all costs. Then India is a democratic, secular and socialist country. A modern welfare state, it cannot permit regressive practices against women in the garb of religion. Now, that is something which cannot be permitted in any progressive society. Cultural practices, if we have to continue with those practices, they must align with substantive equality and gender justice goals. See, society exists, the law exists for society, okay? And it's not the other way around. So the law is to regulate what the people want. Similarly, the customs, traditions, practices. If any custom, if any religious belief, it has outlived its utility, it has to go. And it has to be replaced by a law which is uniform for all and which will protect the interests of each and every person. Now, why do people oppose uniform civil code? That is because there is a reluctance amongst our people to shed our patriarchal traditions and notions. See, one who's sitting in a privileged or an entitled position, why would anyone want to give up that kind of a position? So that is the reason why people, they are opposing. Otherwise, any right-minded person would not oppose the concept of a uniform civil code. See, what happened in Shah Banu Begum versus Muhammad Ahmad Khan, 1985, it's an old judgment. A woman was thrown out of the house after so many years of marriage. And the woman, when she wanted maintenance for herself, the man gave her a very small amount and that too only for 3 months. And he said that after the expiry of Idda, I am not supposed to maintain my wife as per the religious laws. So what the Supreme Court said? It upheld the right of a Muslim woman to claim maintenance from her husband under Section 125 of the CRPC, even after the expiry of the Idda period. Moreover, the courts, they categorically remarked in this case that whenever there is a conflict between the personal law and the secular law shall prevail. So we already had the secular law, CRPC. So under Section 125 of CRPC, the woman, she was granted a maintenance amount. Thereafter, Dania Latifi versus Union of India. See what happened after Shah Banu Begum's case? Immediately, there was a bid to overturn what the courts had done, and that is why the Muslim Women Protection of Rights on Divorce Act was enacted in a haste. And again, what it said that the reasonable and fair provision for the woman for the future of a Muslim wife should be paid by the husband during the Idda period. So it was being misinterpreted in a way that maybe the husband was responsible to take care of his wife only during the Idda period. But then in 2001, finally it was established by the Supreme Court when it said that, see, the future of a Muslim wife, it is not confined to the Idda period. See, so what they said, what is the correct interpretation of the law is that depending upon what is the way of life that a woman is accustomed to, the standard of comfort that she is accustomed to. So depending upon that, we have to arrive at a lump sum amount, a fair and a reasonable amount to take care of the future of the wife, and the payment of that lump sum amount, it has to be made during the Idda period. So it was through a very beautiful interpretation given to this reasonable and fair provision for future of wife that Justice Rajendra Babu, he finally resolved this conflict in favor of women. Then there was this another judgment, Miss Jordan Dengde versus S.S. Chopra, in which the court raised the issue of uniformity in personal marriage. The apex court observed that laws that are related to marriage, such as judicial separation or divorce, are not uniform at all. It also emphasized the need for uniform provisions like an irretrievable breakdown of marriage and mutual consent for divorce to be applied in all cases irrespective of religion. The need for framing the uniform code for marriage and divorce was raised by the court as the court directed to send a copy of its judgment to be sent to the Ministry of Law and Justice. Thereafter, in Sarla Mudgal versus Union of India, the Supreme Court held that a Hindu husband cannot convert to Islam and marry another woman without dissolving his first marriage. It also stated in the same judgment, the court has stated that a uniform civil code would prevent such fraudulent conversions and bigamous marriages. Then there was another judgment, John Valamuttam versus Union of India, in which a priest from Kerala, John Valamuttam, filed a writ petition in the year 1997 stating that Section 118 of the Indian Succession Act was discriminatory against Christians as it imposes unreasonable restrictions on their donation of property for the religious or charitable purpose by will. The bench struck down the section declaring it to be unconstitutional. Further, the court observed, "It is a matter of great regret that Article 44 of the Constitution has not been given effect to. Parliament is still to step in for framing a common civil code in the country. A common civil code will help the cause of national integration by removing the contradictions that are based on ideologies." So you see, the judiciary has been always in favor of a UCC. Then more recently in 2017, in Shaira Banu versus Union of India, the Supreme Court declared the practice of triple talaq as unconstitutional and violative of the dignity and equality of Muslim women. See, Uniform Civil Code was proposed in November 2019. It was again proposed in March 2020, but it was withdrawn in the face of opposition from religious groups and tribals. Then there was a fresh call for Uniform Civil Code in June 2023. And now again, we are talking about this because there has been a fresh call. The 22nd Law Commission of India had recently sought fresh suggestions from various stakeholders on the UCC. In the meantime, we got the Uniform Civil Code of Uttarakhand 2024. This was passed by the Uttarakhand Assembly on 7th Feb 2024. This was notified on 13th March 2024 after the assent of our President, Draupadi Murmuruji. It is applicable to whole of Uttarakhand and also to residents of Uttarakhand who reside outside Uttarakhand. So you see, it has a territorial as well as an extraterritorial application. Section 3, Clause N of the Uttarakhand Uniform Civil Code defines resident as, resident means a citizen of India, whether residing within or outside the territories of state of Uttarakhand who is eligible to be a permanent resident under the notification issued by the state government in this regard, is a permanent employee of the state government or its undertaking entity. So sometimes a person might be posted outside, but if such a person is a permanent employee of the state government or any undertaking of state government, that person would also be governed by the Uttarakhand Uniform Civil Code. Then is a permanent employee of the central government or its undertakings entities employed within the territory of the state. So this is the intra-territorial application of this code. It has been residing in the state for not less than 1 year or is a beneficiary of any scheme of the state government or the central government applicable in the state. So if you want to take any benefits of the state, you have to fall in line and be governed by the Uniform Civil Code, which has been accepted and adopted by the Uttarakhand. So what is the Uniform Civil Code of Uttarakhand 2024? I'll just give you a brief overview of the same. It is divided in 4 parts. Part 1 is related to marriage, divorce. Part 2 is related to succession. Part 3 related to live-in relationships. And Part 4 is miscellaneous. It has got 322 sections. There are additionally 7 schedules in list 1 and 2 of prohibited relationships. Then class 1 and class 2 list of heirs for succession. There is a form of certificate, form of caveat, form of probate, form of letters of administration, form of certificate and extended certificate. Part 1 deals with marriage and divorce, in which in detail, chapter 1 deals with what are the conditions for solemnizing, contracting marriage, how marriage is to be registered, and the new aspect is that they have made registration of divorces also compulsory. Although we know that divorce is again something which is a document, it's a public document which is issued by the court of law, but they have mandated that even divorce statements, they have to be mandatorily registered. Then restitution of conjugal rights, judicial separation, nullity of marriage and divorce, incidental proceedings, jurisdiction, procedure, supplemental provisions. So what are the conditions of marriage as per the Uttarakhand Uniform Civil Code? Section 4 says, a marriage may be solemnized, contracted between a man and a woman if the following conditions are fulfilled. 1, neither party has a spouse living at the time of the marriage. So you see, bigamous marriage, it has been prohibited for all people who are governed by the Uttarakhand UCC, irrespective of their religion, irrespective of their caste, community, irrespective of their own practices. So now bigamy has been prohibited across the board for people who are resident in Uttarakhand, even if they are not residing in Uttarakhand, but if they are governed by the extraterritorial application of Uttarakhand Uniform Civil Code, bigamous marriage has been prohibited. And then, if at the time of the marriage, neither party is incapable of giving valid consent in consequence of unsoundness of mind, though capable of giving valid consent, has been suffering from a mental disorder of such a kind or to such an extent so as to be unfit for marriage, or has been subject to recurrent fits of insanity. So you see, mental capacity to enter into marriage is very important. Thereafter, the man has completed the age of 21 years and the woman the age of 18 years. So we already have a secular law wherein age of marriage that is fixed at 18 for girls and 21 for boys. We already have the Prohibition of Child Marriages Act. But what used to happen was that despite having a secular law, despite the Supreme Court having declared in Shah Banu that whenever there is a conflict between the personal law and secular law of land, the secular law will prevail. Despite all this, what was happening that people would regulate their marriages in accordance with their personal laws. And many times the courts were also reluctant to intervene. So now it has been very clearly established by the legislature also that in order to enter into a valid marriage, the parties should be of marriageable age as per the law, which is 21 for boys and 18 for girls. Then the parties are not within the prohibited degrees of relationship unless the custom or usage governing one of them permits between the two, and provided that, again, although we have given primacy to customs and usages, but those customs and usages should not be against the public policy and morality, and that the marriage is not prohibited under any law in force. Thereafter, what are the ceremonies in marriage? Now, this is a very beautiful provision which makes it very, very clear and which demolishes any sorts of doubts that people might be having in their minds that UCC would be against our religious freedoms or against our cultural diversity. It would maybe stop us in celebrating our marriages or our ceremonies. See, the law makes it very clear. Marriage may be solemnized, contracted between a man and a woman in accordance with the religious belief practices, customary rites and ceremonies, including but not limited to Saptapadi. See, in Hindus, Hindu Marriage Act, Saptapadi is mandatory for all Hindus. Whereas, as I discussed earlier also, there are so many communities amongst Hindus wherein Saptapadi is not a compulsory, a mandatory requirement for marriage. But that is what the Hindu Marriage Act said. But now, as per this law, Saptapadi is not mandatory. So whatever your own customs, rituals they dictate, you can conduct your marriage rites and ceremonies as per that. Similarly, whether it is Ashirvad, whether it is Nikah, whether it is Holy Union, whether it is Anand Karaj, okay, under the Anand Marriage Act as well as under, but not limited to the Special Marriage Act and Arya Marriage Validation Act. So you're free to celebrate your wedding ceremonies, free to celebrate your festivals, functions, whatever, as per whatever rituals and customs your religion prescribes, whatever you believe in. But when it comes to the conditions, that is something the state is going to regulate. See, religious practices, as I said earlier also, it cannot be allowed to trample the rights of one particular section of the society, especially women. So that is why there is no threat whatsoever to anybody's religious freedoms, no threat whatsoever to celebration of our rituals and practices. But when it comes to rights and obligations of the parties involved in an institution, whether it is the institution of marriage or whether any other institution, we have one uniform law now that would govern all the residents of Uttarakhand. Then what are the grounds of voidable marriage? Now, this is again a very progressive provision in the sense it says, any marriage solemnized, contracted, whether before or after the commencement of this code, shall be voidable and may be annulled by a decree of nullity on a petition presented to the court on any of the following grounds: that the marriage has not been consummated owing to the impotence or willful refusal of the respondents. Because as we said, conjugal bliss is one of the important goals of marriage. So either of the parties cannot be compelled to stay in a relationship with an impotent spouse or where the other spouse is not willing to consummate the marriage. So that is a valid ground to get the marriage annulled. If the marriage is in contravention of the conditions specified in clause 3 of section 4, that is age related, that the consent of petitioner was obtained by force, coercion, or fraud. See, it's not a free consent, and what is required is a free consent of both the parties who are adults to the marriage. And second, this point, see, so long as till date, if we talk about the Hindu Marriage Act, the law says that it's a ground for declaring a marriage as a voidable marriage if it can be proven that at the time of marriage, the woman was pregnant by a man other than her husband. Okay, so for the longest time, this was treated as a very, very discriminatory provision, because what would happen in case it could be proven that the husband, he had already impregnated any other woman at the time of marriage. So the Uttarakhand Civil Code, it takes care of that also. Look at clause D of section 24. It's uniform, whether we are talking about men, whether we are talking about women. What it says is that the time of marriage, the wife was at the time of the marriage pregnant by a man other than the husband, or that the husband had at the time of the marriage impregnated a woman other than the wife. So in both the cases, now both the man as well as the woman, they have equal rights to opt out of the marriage to get a degree of nullity. Moreover, when we are talking about provisions as to marriage, you have to look at the language. It says, any marriage solemnized, contracted. So now contract is a term which we would usually associate with Muslim marriages. For Hindus, it is treated as a sacrament. Now, what does the law say? Any marriage solemnized and contracted. So we are not even trying to hurt the religious sentiments or sensibilities of any particular group of people. Then there is a prohibition on dissolution of marriage. It says no marriage solemnized, contracted before or after the commencement of this code shall be dissolved in any manner except in accordance with the provisions of this part, notwithstanding any usage, custom, tradition, personal law of any party to the marriage or any enactment to the contrary. So what it says is that the dissolution shall be only as per the law. Okay. It's very, very clear now. You don't have any customs practices. Okay, now I can leave my wife at my own whim or caprice. That is not permitted anymore under the law. And it says right of a person to remarry when a decree of divorce or nullity or marriage has been passed. So what it says is when a decree for divorce or nullity of marriage has been passed, and either there is no right of appeal against the decree, or if there is such a right of appeal, the time for appealing has expired without an appeal having been presented, or an appeal has been presented but has been dismissed, it shall be lawful for either party to the decree to marry again. And right to remarry under subsection 1 includes the right to remarry the divorced spouse without any condition, such as marrying a third person before such marriage. So the reprehensible custom of halala, which requires a man who has divorced his wife not to marry his wife unless and until the wife marries another man, she consummates the marriage with that man, thereafter that man divorces her, thereafter she observes the iddah, and only after that can her first husband remarry her. So all that kind of things that a woman, she is compelled to undergo in the name of religion, in the name of custom, that has all been put an end to by this. Then part 2 deals with succession. Now, this is so much in detail, but one thing is very good, that laws of succession, whether it was related to Hindus, whether it was related to Muslims, and Hindus also, when there were different laws that governed the Mitakshara, succession and inheritance, now there is one uniform set of laws for everybody. This would be, in fact, very easy for law students also to understand. And I'm sure in the course of time, people would also have accepted more easily and in a more open manner. Then part 3, which is the most contentious part in this code, because for the first time, law has tried to regulate live-in relationships, and people are criticizing this law left, right, and center. They are saying that the state is trying to be moralistic, or the state is trying to intervene in personal matters. But there is some logic behind these provisions also, and that is, when people, they are being exploited in these relationships, in the garb of these relationships, when women, they are being subject to repeated rape, and when men, they are being subjected to false accusations of rapes by women. So when it is clear that it is a live-in relationship, when the rights, duties, obligations that the parties want out of their relationship, that would be spelled out loud and clear in black and white, then in such circumstances, the abuse of either of the parties would stop. So what it requires is submission of statement by partners to live in relationship. You want to live in a relationship, you should be capable of entering into a marriage. That is, the age and all those conditions will apply. And after that, you have to submit a statement to the registrar. You don't need to hide it. If you are bold enough to go against the societal norms, to go against the tradition of marriage and stay with the person of your choice, you should be brave enough to also speak it out loud. See, once we will have acceptance, a legal acceptance of live-in relationships in this manner, the judiciary has already granted acceptance to live-in relationships. When the legislature will also grant recognition to live-in relationships, the stigma that is associated with these relationships will come down, and that will be a very positive thing. And thereafter, what the law says is that till the time you are staying together, it is okay. The moment you want to terminate your live-in relationship, you have to issue a statement of termination of live-in relationship. See, so clear. Right and obligations when you are in a relationship, when you are out of a relationship. It is all well defined. Children of live-in relationships, there is no such thing as an illegitimate child. All children would be legitimate and they would be entitled to all sorts of rights. Then the law also lays down what is the procedure for registration of these live-in relationships and what are the consequences of non-registration. The powers and duties of registrar, that he can issue a notice to the parties who are choosing to stay in a live-in relationship if they have not got it registered, that you've been given so much of time that you have to come to the registrar office and you have to get it registered. What are the offenses and penalties, and also maintenance to women in live-in relationships. Although DV Act does provide some sort of a protection, but then again, there is a gray area when it comes to bigamous relationships, bigamous live-in relationships. So that has been made very, very clear herein, because bigamous relationships now, they have no legal recognition at all. Relationships should be in the nature of marriage, and only then such relationships, they can be registered, and only then can the parties to such a relationship claim any rights. See, what is the provision relating to submission of statement by partners to live-in relationship? It says, it shall be obligatory for partners to a live-in relationship within the state, whether they are residents of Uttarakhand or not, to submit a statement of live-in relationship under subsection 1 of section 381 to the registrar, within whose jurisdiction they are so living. Any resident of Uttarakhand staying in a live-in relationship outside the territory of state may submit a statement of live-in relationship under subsection 1 of section 381 to the registrar, within whose jurisdiction such resident ordinarily resides. Any child of a live-in relationship shall be a legitimate child of the couple, and a live-in relationship between two persons shall not be registered. Where the partners are within the degrees of prohibited relationship as defined under clause D, provided the prohibition will not apply to persons whose customs and usage permit the relationship it were a marriage, provided further that such custom and usage are not against public policy and morality. Where at least one of the persons is married or is already in a live-in relationship. So if you are in a bigamous relationship, you are already married, you want to get your live-in registered, the law will not permit it. You are in one live-in relationship, you want to enter into another live-in relationship, The law will not permit it. Polygamy is not to be permitted. Polygamy, polyandry, not to be permitted. Then, where at least one of the persons is a minor, again, it is not to be permitted. Both the parties, they have to be adults. Where the consent of one of the partners were obtained by force, coercion, undue influence, misrepresentation, or fraud, as to any material fact or circumstance concerning the other partner, including his or her identity. Again. So now this is, because see what happens if a person has concealed his or her identity. See, this has been happening. There have been cases of love jihad and so many other things when people, they misrepresent themselves to be belonging to some other religion, or they misrepresent, they say, I am working in this establishment, or I am this person, which the person is not actually. Then registration is not to be permitted. Then what is the procedure for registration? Partners to live-in relationship or persons intending to enter into a live-in relationship shall submit a statement of live-in relationship to the registrar concerned in such format and in such manner as may be prescribed. The state is going to prescribe the format. The registrar shall examine the contents of statement of live-in relationship so submitted and satisfy himself herself by conducting a summary inquiry that live-in relationship is not of such a kind as is mentioned under 380. That is, there is no minor involved, it is not bigamous and all those things. In conducting summary inquiry under subsection 2, the registrar may summon the persons, partners, or any other person for verification in the prescribed manner and require the partners, persons to supply additional information or evidence if necessary. After conducting such summary inquiry as may be deemed appropriate, the registrar shall, within 30 days of receipt of statement of live-in relationship under subsection 1, either enter such statement in a prescribed register for registering the live-in relationship and issue a registration certificate in the prescribed format to the persons or partners, or refuse to register such statement, in which case the registrar shall inform the partners, persons of the reasons in writing for such refusal. So you see such a clear-cut procedure laid down in black and white. This has all been done with a view to eradicate the stigma. See, we have to accept that nowadays, increasingly young people, increasing large numbers of young people, they are choosing to stay in live-in relationships. So when we are making it so clear and we are making the registration mandatory, so what we are doing, when there is a legal stamp to these things, the stigma, it is going to reduce. Then registration under this part, it is only for the purposes of record. Then submission of statement, okay, of termination of relationship. Both partners to live in relationship or either of one of them may terminate it and submit a statement of termination in the prescribed format and in the prescribed manner to the registrar within whose jurisdiction such resident ordinarily resides, and provide a copy of the statement to the other party in case only one of the partners terminates the live-in relationship, so that the other partner also gets a notice of the same. Then any statement of live-in relationship submitted under 1 of 381 shall be forwarded by registrar to officer in charge of local police station for record, and in case either of the partners is less than 21 years of age, they will inform the relatives or parents. If the registrar comes to the conclusion that the relationship is of such a kind as mentioned under 380, or that the contents of statement under subsection 1 of 381 are incorrect or suspicious, he shall inform the officer in charge of the local police station for appropriate action. Or any statement of termination being submitted under 384 by one partner to a live-in relationship, the registrar shall inform the other partner about such statement, and in case either of the partners is less than 21 years of age, also to the parents or guardians of such partners. See, now this is going to resolve so many problems when we talk about people who want to stay together, young people, but they don't get a house on rent, landlords, they are reluctant to give it. So when the state has accorded a sanction to their relationships, nobody will be having any objections. People will not be unduly moralistic, people will not be unduly preaching to them. Notice for registration of live-in relationship. Where any partners to a live-in relationship has failed to submit the statement of such a relationship, the registrar, either of his own motion or in receipt of a complaint or information in this regard, shall by notice require such partner to submit a statement in the prescribed manner within 30 days from date of receipt of such notice. And once they receive such a statement, the registrar shall act in accordance with the procedure. Then live-in relationship, there are offences and penalties. If you don't inform the authorities and if you've been staying in a live-in relationship for more than 1 month, then there is a provision for imprisonment up to 3 months and a fine up to 10,000 rupees. Similarly, the statement of live-in relationship which you have submitted to the registrar, if you've made any false averments as to your age or any other thing, if you have withheld any true information, you were already in a relationship, or if it is a bigamous relationship, then the punishment could be up to 3 months or 25,000 fine. And failure to submit the statement of live-in relationship on being required by a notice, then the punishment can go up to 6 months or 25,000 rupees fine. Maintenance, there is a provision for maintenance, but only to the woman, live-in partner. If she is deserted by the partner, the woman can claim maintenance. So you see, it would be easier for women to claim maintenance if there is already a statement of live-in relationship which is registered by the registrar. She would be in a better position to claim maintenance if she is deserted by the live-in partner. But there are some concerns relating to the Uttarakhand Uniform Civil Code. One is the tribals, they have been kept out of the purview. See, although it is very difficult to regulate tribals because they have so many different peculiar customs and traditions which they follow, but then again, law is meant to do these difficult tasks. Law is meant to make these difficult tasks easier. Some sort of uniformity, it has to be implemented. So at least they could have made an attempt at bringing in some aspects of tribal laws under this kind of a governance. Then there are accusations of a moral policing by the state. Thereafter, there is this concern, which is the marriage registrar, which is open to scrutiny by any person. Now, this raises concerns regarding privacy. Another important aspect is non-recognition of trans persons. Although it uses the term persons, although it uses the term children, these are persons, children, these are gender neutral terms. But then it uses expressions such as sons, daughters, sisters, brothers, husband, wives. So as it is, when you go through the provisions in detail, you find out that despite having the Transgender Persons Right to Identity Act of 2019, they have not been granted any sort of what we call as an identity under this law or any rights. Then registration of divorce, it's already a public document. I somehow fail to understand what could be the purpose behind making registration of divorce as mandatory. So why do we, after talking about Uttarakhand Civil Code, let us just try and understand in very brief, why do we need a uniform civil code? And that is because there are so many inconsistencies in various personal laws across the country. Like you see, Hindu undivided families, they are exempted from paying taxes. Muslims are exempted from paying stamp duties on gift deeds. Muslim law does not permit adoption. Hindus practice dowry, Muslims practice dower. Muslim law permits polygamy. There is no uniformity in succession laws, not between Hindus and Muslims, amongst Hindus also. There are different schools. Then there is no uniformity in grounds of divorce. There are differences in marriageable age. Muslim women, they cannot remarry before expiry of iddah. There is also this reprehensible custom of halala. There are this and many more inconsistencies in various personal laws which can all be resolved by having a uniform civil code. So what is the way forward? We need to identify discriminatory and oppressive practices, and we need to consider progressive views that align with the constitutional goals of equality and justice. By uniform civil code, the existing inequalities can be rectified, ensuring that women from all religious backgrounds are granted equal rights and opportunities. Issues like child marriages, polygamy, triple talaq, right to maintenance, inheritance, and property rights can effectively be addressed by UCC. UCC has the potential to foster national integration and secularism by establishing a shared identity and a sense of unity amongst all Indians. Somehow, the Uniform Civil Code of Uttarakhand, there are fears that it might in fact lead to regionalism. Because now, with Goa having their own civil code, Uttarakhand having their own uniform civil code, the rest of the Indians, they being governed by different sets of laws in their personal matters, there could be some sort of a regionalism that it might perpetrate. So what is required is one code for all of the country. Now, having one single code would address the communal and sectarian conflicts such as love jihad, honor killings, which arise due to various personal laws. It would also streamline the legal system by eliminating the complexities and contradictions that stem from multiple personal laws. It would harmonize civil and criminal laws. It would eliminate any anomalies and loopholes that arise due to diverse personal laws. UCC would modernize and reform outdated and regressive practices that are prevalent in certain personal laws. It would eliminate practices that infringe upon human rights and values that are enshrined in Constitution of India, such as triple talaq, polygamy, child marriage, and others. So that will be all from my side. Thank you. So any questions? Since nobody is asking any question, there is one question that was asked by Ashwini Deo. He says, first and second point is self-contradictory. Prenuptial agreements can override first concept of common matrimonial property. See, what we were talking about was that Goa has the concept of common matrimonial property. If we have prenuptial agreements, there would be no need for common matrimonial property. In fact, having prenups would be even better than having a common matrimonial property concept. Prenuptials would be very, very clear as to the rights and responsibilities. Common matrimonial property would talk only about the economic security of a woman, about the property which she takes. Prenuptial agreements can be very, very broad. Exactly what are the rights, what are the obligations, what are the expectations that parties have from each other in a relationship, and the ease of exiting the relationship. All this and more can be included in a prenup. So prenups would be definitely even better than having the concept of common matrimonial property. And if we wanted, we could always introduce the concept of common matrimonial property within the prenup. Okay. So there is another question. Does non-registration or termination of a live-in relationship mutual or individual in nature? If individual in nature, could it be problematic? What this means is non-registration or termination mutual. So it has to be mutual, both the parties. See, if it is given by only one of the parties, the registrar will give the notice to the other party, whether it is statement of registration, whether it is statement of termination. It has to be mutual. Okay. Then second is, why shouldn't a live-in relationship status be granted to married people if they were to be in an extramarital affair, which would mean that benefits of sexual abuse, false accusations, and maintenance would not apply to them? This might also, no. Extramarital affairs and live-in relationships are two different things. Live-in relationships, they cannot be bigamous. Extramarital affairs are bigamous, which is hurting the sentiment of a person. When you enter into a relationship, there is the concept of exclusivity that is meant to be maintained in a close relationship, whether it is a live-in relationship, whether it is a concept of marriage. Okay. So see, again, we cannot be preachy or moralistic in the 21st century. I get the sarcasm that is in the question, that you mean to say that when law is legalizing live-in relationships, that is a wrong step. No, that is not that. See, it is something which has been happening all around. If we would at least accord a legal sanction, we could be able to regulate it and stop the abuse of people that is happening in the garb of those live-in relationships. That is a very good step that has to be taken. See, just because we cannot close our eyes to a social problem that is there in front of us. We need to address it. Then there is a question. There is a question by Mansa Ranjan Mishra. What are the main hurdles in implementing UCC across the country, and what should be the lasting solution? So the main hurdles are people, they are not clear about what a uniform civil code is. People are scared that it is going to destroy our religious beliefs and concepts, and it will destroy our cultural diversity. Whereas, as I made it very clear, we are free to celebrate our festivals. We are free to celebrate our rituals. We are free to hold our marriages as per the customs that have been prescribed. The only thing is it cannot be permitted that a man will keep 3 or 4 wives, that a man will at his whim divorce his wife. Okay, so all these things, they are not to be permitted, because it's a woman. At the end of the day, a woman, she's an equal human being too, with equal rights as the man. That is what our constitution says. So accordingly, the constitutional goal 44, it has to be given effect, and it's high time that we brought in a UCC now. Do we have any other questions? Yeah, yes, there are other questions. Hoysala asks, ma'am, what are the aspects of moral policing which have raised concerns? Yes, people believe that, see, we are trying to regulate people who are trying to live in relationship. So that is the aspect of moral policing that has been raised here. That, see, when we talk about live in relationships, these were meant to be relationships of in which people were entering who were not bothered about the societal norms. Okay, they did not accede to the norms, and that is why they were opting to live in relationship outside the institution of marriage without entering into the institution of marriage. So in the 21st century, where two consenting adults want to stay together, what is the problem? That is what our Supreme Court says. So when we are trying to legally regulate it, so there are people who are objecting to this, that see, the law has no business to intervene where there are two consenting adults involved. The law has business to involve itself only because there is a possible of a very ugly fallout between those two people at a later date. In case of marriages also, what happens when there is a dispute between the parties? Similarly, in case of live-in relationships, when the exit point is easier, in such cases, disputes, they are bound to happen. So by this, law is just trying to address the issues of parties involved in those live-in relationships. But yet, people, they have their genuine concerns also, that it is only when people, they don't want to be regulated by the law, that they are going in for live-in relationships. So why does the state have to intervene? So anyway, it's a debate which has both sides. And that is it. Any other questions, please? So there's a question by the administrator. Is it that UCC is left to individual states' discretion to implement or not? If it is so, how is it going to be uniform? Exactly, that is the query. That instead of bringing in uniformity, there could be regionalism. So that could be problematic. So that is why there is a necessity to bring in a uniform civil. The states could have some minor what we call as differences from the main code, but by and large, they should be expected to adhere to the one uniform civil code which is prescribed by the center. That is how our criminal laws also work. So if that is all, can we call it a day? I don't think we have any other queries.